In studio with me is Brad Micklin. Brad, this is a little strange. You got 40 potential witnesses. You're looking at a manslaughter case. You're trying to say it was self-defense, and you only call 2 witnesses. What do you make of that?
It was shocking to learn that. I actually didn't believe it at first when they told me that because, again, there was 40 witnesses. If you listen to the defendant's opening statement, the counsel goes through a ton of people that he's planning to call, all these people that were involved in the fight. There was a toxicology report that says that there was PCP in the victim's bloodstream, and apparently none of that came out. I'm assuming that maybe the prosecutor just missed a significant element, and the defense decided just to go on that and not to push opening the door.
Yeah, I was thrown on the fact that they only called these 2 witnesses. We are actually going to go to a quick break here, but again, okay, we're still watching live the defense closing arguments in the Demetrius Elder case. A lot of moving parts. Still here in the studio with me, Brad Micklin. Brad, a lot going on here. You got this fight, you got weed, you got alcohol, you got PCP, but I want to touch on something. The defense, actually, one of the key witnesses in this case was a friend of the victim, Corey McMath. You heard him just say something about Corey being a convicted felon. What does that have to do with anything other than trying to discredit him as a witness?
I don't think it has anything to do with it. I'm actually surprised that it was found to be relevant whatsoever. But we have to assume this issue was raised pre-trial, and normally you would exclude evidence that's not relevant. So there had to be some showing that it would tie into it. Now, I know from the defense opening argument, at least, that they were trying to allege that Corey sort of instrumental in creating this, that he brought Muhammad in for the purpose of this fight. So maybe they were trying to tie together the kind of person that Corey is, having this violent past, and is more likely to have done something like this.
Yeah, and that very well could be. And you and I were talking while we were listening to this closing argument here. There's a chance, in my opinion, that maybe Demetrius does walk on this because there was just so much going on. It would be different if it was just a road rage incident and the horn blew, he got out, the fight occurred, and then there was a stabbing, but you had this party, you had this fight, you had alcohol, you had drugs. What do you think?
I agree. I mean, I don't think there was much testimony from the opening statements through the closing statements that really tied Demetrius to a weapon and to the fight.
Right.
And I think what might be really interesting now is Armando, I believe, gets tried next. And he's probably going to be able to say, it was Demetrius. It wasn't me.
Right. And maybe that's why they didn't call him as a witness. And you made a very good point there. Like, there's just so much going on, but we've heard several testimonies that said Demetrius was not even there when this whole thing started.
Right.
So it goes back to this whole manslaughter charge. He wasn't there.
Well, I think he was in the car. I mean, both the prosecutor's opening statement and the defendant's opening statement put him in the car, but neither of them seemed to tie him to, like I said a moment ago, to the weapon or to the fight. So it was really unclear.
Or to the fight. That's what I meant. He wasn't there during the fight. And then, again, like we heard Corey say, Muhammad wasn't a violent guy, and I wouldn't allow that at my house. Just so many moving parts to this case. Okay, still hearing closing arguments from the defense in the Demetrius Elder case. And he's been up for about 20 minutes now, still in studio with me, Brad Micklin. Brad, you and I were talking, and the prosecution actually finished her closing statements in about 5 minutes. The defense has been up for quite a while now. Why do you think she was so quick in her closing argument?
My thought is that she's just not that good of a prosecutor. If you look at her opening argument, it was about 7 minutes long. I've argued motions that are 10 times that. And the defense opening argument was nearly twice that. But also, I think she might be trying to keep it closed because she has a death on her hands. She has some eyewitnesses. So maybe she's just trying to keep it more compact so that there's not reasons to argue reasonable doubt. I can't really tell yet.
Yeah, but she also can do a rebuttal once the defense finishes their closing arguments, correct?
Could be. I think some judges do and some don't. So we'd have to see what this one's going to do.
Yeah, now, with that rebuttal, I think she should have gotten everything she wanted to say out ahead of time versus waiting on this rebuttal because, I mean, to a juror that's going to say, well, why didn't you say that the first time? Why are you just now coming back? Were you not prepared? To your point, is she not that great of a prosecutor?
Well, if she knows that she's going to have this rebuttal, that may be different because I would certainly want to be the last thing that they hear before deliberating. So whatever points she has to make, whatever smoking gun she has, no pun intended, but she might be keeping that in her back pocket. So if she knows that she's going to close or rebuttal, then she's going to save that for that.
Yeah, and I think the defense is doing a really great job bringing out a lot of points and a lot of questions to make people have that reasonable doubt that they need to have in this case. Again, this is a manslaughter case in the state of Florida. Demetrius Elder is on trial right now.
This is an interesting case. The jury really has a lot of factual calls to make here. That's what juries are for. And this case has got a lot of he said, she said, a lot of conflicting facts that jurors are going to have to resolve. Brad Micklin is an attorney. He's here with us. Brad, good to see you. I appreciate you being on. So what do you make of this? This is a lot of factual back and forth for the jury to really dive into here.
Well, I think part of what's going on sort of both sides, I mean, obviously we have a prosecutor who's trying to prove manslaughter, which isn't the highest of burden, but we have obviously a defendant who's looking to prove reasonable doubt. And I think that's what we heard more about, because the prosecutor's rebuttal sounded more like she was on the defensive, as opposed to trying to establish the act that led to the manslaughter. So when you look at the defendant's case, where we have Muhammad on a combination of drugs, one I believe being PCP, and all these other people, Corey and Demetrius, and this alleged history of the fights and the revenge, as they so called it, I think you're really creating a lot of potential reasonable doubt. And I think that's what the prosecutor was trying to work against in the rebuttal, as opposed to just establishing the manslaughter.
Yeah, it's interesting. And you know, a lot of people are like, well, this isn't a long, drawn-out closing argument. We often see them. But manslaughter doesn't have a lot of elements in Florida. They don't have to prove premeditation the way they would in a first-degree murder case in Florida. Or they wouldn't have to prove in Florida on a first-degree murder that it was a murder that happened which was attached to some other underlying crime. Okay, so the burden for the state here is a lot lower than it would be in a lot of the other types of crimes that we follow. Could that account for the comparative brevity, I guess you could say, of the closing arguments here?
I think so. I was on a moment ago with Vincent before you signed on, and he and I were talking about that. I'm not a big fan of the prosecutor, at least how she handled a lot of parts of this case. But I think, I don't know if it was her decision or the office itself, but I think the not charging murder and charging manslaughter was actually a brilliant choice, because the whole, this is a revenge fight that the defense was bringing up, they could have flipped it and used the same type of argument that this was a revenge killing and gone for murder. And I think that would have been a hard charge to sell to a jury given this convoluted fact pattern. So I think the manslaughter made a lot of sense.
Yeah, exactly. Who did what, when, why? What was going on at this party? Was the victim, who went by the nickname Mohammed, was he there to settle a dispute? Was there something going on? You know, and in whose mind are we looking? Are we looking into the defendant's mind? Are we looking at the stereotypical reasonable person standard? Would a reasonable person have felt threatened by this action? You know, this is late. This is a stop sign. Why somebody who was at a party, who allegedly was there to settle a dispute, suddenly coming for me? The defendant might have been wigged out in that situation. You know, is it reasonable? A lot for the jury to really dig into here. Welcome back, everybody. We are talking about the case wrapping up today in the Demetrius Elder manslaughter case out of Florida. Jurors got the case about 10 minutes ago. We're waiting to see how quickly they may or may not come back with a verdict. So, Brad Micklin is an attorney. He's here with us on the Law and Crime Network. Breaking this down a little bit, we've got a lot of different factions of people testifying, and what we listened to right before the break was a friend of the victim, and he's saying, oh, no animosity, there wasn't anything bad going on, but I would expect when there was cross-examination of him that he would have been impeached because he was a friend of the victim. He's probably not going to get up there and say the victim is an aggressor.
Right, well, that's one of the pieces that didn't make a lot of sense to me. Aside from, and I know I commented before about the prosecutor, and I've never been a prosecutor, and I understand it's a challenge deciding who to charge, what to charge, when not to charge.
And you don't get to pick your witnesses. Right. That's the other struggle.
But here we had a witness that apparently was brought in by the prosecutor. I had two issues with the testimony. First was, if you listen to her examination, most of it was open-ended questions. Yes or no's, or I mean closed questions, like leading questions, yes or no's, where it's supposed to be open, who, what, where, why, when, and how. And she's leading the witness as opposed to examining and walking them through the testimony, but the defense didn't say a thing. So they let it go. But then the testimony itself almost seemed like she was trying to negate what the defense was going to be bringing out, that this was a revenge killing, where her job is just to establish that there was death. So I didn't even understand why she would call this witness as her own.
Well, you know, you get into a lot of sort of funky procedural things in Florida, because I did read some of the pretrial documents in this one. This case happened before the current incarnation of Florida's Stand Your Ground law. And there's a lot of litigation in Florida about it, just exactly how far back that new law can be used as a shield by a defendant in court, sort of retroactively, because there's an incident, then the law changed, and then trials happen. So it's like, is it a procedural rule or is it a substantive rule? And there was a lot of back and forth about that. So some of the jockeying I think we were seeing was a result of that. You know, once the defendant says, Florida, stand your ground, it puts the prosecutor on, you know, if not an additional legal burden, then certainly an additional edge to try to override that claim by the defendant. And we watched that play out in closing arguments. I think that some of that was what we may have been watching.
Yeah, that might have been, because most of the reviews that I've heard about this case did characterize it as a stand your ground case. And I know it's very controversial in Florida, so I thought that's what the defense was going to be bringing out. And then again, all we keep hearing from the defense is that it was a revenge killing. So I was kind of confused at what the actual theory was when you listen to the opening arguments, where they're supposed to be sort of mapping out not only the land of the testimony, but what the theory of the case is going to be. You didn't really hear this stand your ground claim come up at all.
So it was interesting. That's cross-examination. We heard more open-ended questions on the cross than we did on the direct. It seems like the defense wants to just let him tell a story, because he's talking about drugs that they were taking, and he was sort of digging his own grave from the witness stand.
Yeah, that's how I heard it too. I mean, he first appeared when he was testifying for the prosecutor. It was very credible, even though he was being led to his answers, because it was a fleeting answer, but he admitted to smoking marijuana. So to some extent, while that might not be the best thing to admit, at least he's credible. He's not hiding behind a different type of story.
He's not lying about it, but, you know, does that affect his perception of the events that he's testifying to? He's saying, you know, oh, the victim is peaceful, this, that, and the other thing. Well, if he's high on marijuana, does he really know what's going on?
Well, and I still have trouble seeing the relevance of this in the first place. He wasn't there. He testified he didn't even see it. The altercation happened down the street, if not further. So other than this revenge killing that the defense is trying to bring out, which I don't even know if they need to establish at this point, I didn't see the point of even calling this witness from the prosecutor's standpoint.
Testimony from the victim's girlfriend about how this fight broke out in her version of the events here. So we've got a couple different versions of events here that jurors are going to have to try to weed through. Brad Micklin is still here with me. Brad, what do you make of this? Is she credible? Is she covering for the victim? How should jurors take this?
There's a lot of layers to a witness like this, because we have to acknowledge that she's a victim herself. I don't know how long-standing her relationship was, but she's certainly a victim. But that also gives her some incentive to see things differently. I'm not suggesting that she's going to lie or change the facts, but her perception is certainly going to have a different perspective, because she wants to vindicate her boyfriend's life, and I can't see that as causing her to be consistent with what maybe other eyewitnesses might have seen.
You know, one thing that strikes me in listening to her version of the events is she's saying it's not so much the defendant as it was the other person who, you know, could be described as an alleged accomplice here, because the defendant and another person were in one vehicle, and then it was the girlfriend and the victim in another vehicle. It sounds like the first punch, if we're to listen to and believe her version of things, wasn't this defendant.
Right, and that's the problem I've had with this case since the opening statements, is that I haven't heard either side, the prosecutor or the defense, actually tie Elders to the stabbing or even to the weapon. So this whole road rage issue or revenge killing, whichever one it was, doesn't necessarily involve Elders, at least at this point that we're hearing.
Is this a situation where Elder is going to be able to say, hey, look, these two start going at it, it spills over into me as that girlfriend just testified, and then at that point, everybody's throwing punches, and at that point, I have to defend myself?
That could be, but obviously I don't believe he testified, which I think was a good choice, because you don't want to take the stand as a defendant in a manslaughter case unless you absolutely need to, and as a defense attorney, it's rare that you're going to do that. So while he could have, it's smart that he didn't.
Brad Micklin is still here with us on the Law and Crime Network. And Brad, look, here we've got some testimony from a police officer saying that the aggressor here, according to the victim's girlfriend, really didn't have any kind of wounds on himself. So does this lend credibility to that girlfriend whose testimony we listened to a little while ago, where she says this basically was her boyfriend who was bearing the brunt of the injuries here? It wasn't the person she says was the aggressor.
Yeah, I think it scores several points that the prosecution wants to make. I think, first, the officer identifying the solo cup does sort of set the tone that he got out and maybe he was going to shake his hand. He didn't have a weapon in his hand. But also, there was testimony that they had to find the car and that there wasn't any marks on this. And I think that's going to open up a claim that they fled the scene because they knew they did something wrong.
Yeah, this is an interesting piece of testimony to plug into what we heard earlier. But look, how long ago was this fight from the point that they served the warrant and then try to examine this guy? Is that? I'm sure that it's been discussed. I just must be missing it in here somewhere.
Well, I think that's going to be either something that comes later or something that we hear with cross-examination. I think the defense counsel is going to be charged with also showing what the police officer didn't see or isn't qualified to determine. He's not a medical officer or medical educated in any way to know whether there would be a bruising and how long it takes for that to surface. And things like that, I think, are going to be subject to the cross-examination.
Jurors have a lot of facts to try to reconcile, and what they asked for was a transcript of testimony from Wendy Gimbolis, who we were just listening to, the girlfriend of the victim, and they wanted a transcript of the defendant's own testimony from a stand your ground hearing. They are trying to reconcile whose version of this attack at the stop sign makes the most factual sense. The judge said, look, you can get a playback of the video, but there is no transcript and evidence, and you can get a readback of Wendy Gimbolis' testimony. He said it might take a while, so this might push into next week from a timeline standpoint. But look, two different versions of what went down there, the defendant's and the victim's girlfriend. Who should the jury believe? And of course, we don't know the answer, but it's the rhetorical question. They're trying to reconcile that testimony.
Well, that's the jury's job. So when they ask to see something, you would hope that they would be able to get it, especially in a typed form, so there wouldn't be any question of interpretation or recollection. Now, I believe this is more of a technicality where the judge said you can watch it. You can't read the transcript because we didn't move it into evidence, but having to watch it means you have to watch all of it or at least large portions of it.
Yeah, I mean, look, but I think the jury's doing what the jury is supposed to do. And ironically, of course, they're asking for pretty much the same exact stuff that we were playing back earlier today, trying to reconcile the facts from the two people who were there at the scene. That's exactly what they're trying to do. They want to hear from the defendant. They want to hear from the other person who was there. Jurors in the Demetrius Elder manslaughter case basically asked for some of that exact testimony to be played back. That's part of his version of what led up to this stabbing at a stop sign after a group of people, the victim and the defendants, were at a party. Jurors are trying to reconcile that with testimony from the victim's girlfriend that does not line up with that testimony. So, Brad Micklin, this is the whole reason we have juries. They have to reconcile who's telling the truth and who's not.
Right. I mean, and both sides of this case had some strange aspects to the story that left me with questions. You know, and when you're looking to the defendant taking the stand your ground defense, they were the car in the front. They were at a stop sign. The question, why didn't they just go? You know, their refusal to move seems to what brought this about. So that is what drives weird about their whole position. But yet the defendant's position is I got out holding a solo cup and went to shake his hand. That doesn't make sense either. So I can understand why the jury is going to have trouble reconciling both of these stories.
Yeah, exactly. You know, and I thought, if I'm remembering my facts correctly, didn't the car behind sort of pull up and then beep, and then, you know, so it's like, what did the person in the front car, if we're to believe the defendant, did he think that somebody back there was trying to get his attention for some reason? And if this theory that there was some animosity brewing at this party, if that was correct, maybe he was on edge instantly because of the beep. He knew what was going on. Well, we're going to wrap up the broadcast today in just a minute. Brad Micklin, we appreciate you being here. It's great to have your analysis.